The National Education, Health and Allied Workers Union wants the Department of Health to appoint community health care workers permanently. They have taken the community workers' plight to the Labour Court today, calling for the recurring fixed-term contracts to be abolished. Mike Shingange is Nehawu's president and joins me now. Mike, a very good afternoon to you. Thanks very much for your time. You won the review of the award. You've lost previously. What makes you think you will win this time around?
Good afternoon, Potfu, and your viewership. This is a recourse that is in our disposal as workers after the arbitration award by the arbitrator who relied on the evidence which we believe was incorrect in law. And that is why we came to court to argue the case that the Act provides that you cannot appoint people on a fixed term contract that is more than 3 months unless it's regulated by a collective agreement or it is stated so at the beginning. And we are here. There couldn't be no evidence that indicates that there was an intention to appoint people on a fixed-term contract that more than 3 months. You will remember, that these workers have been on the fixed-term contract renewable every 3 months or every year for many, many, many years. Many of them work for 20 years, 25 years, and by the time they retire, they have nothing to show that they've been rendering services to the state. They have nothing to show that they've been rendering essential services, which is the public health care services to our vulnerable people. There's nothing to show that they were ever contracted or related to the Department of Health. So what we are asking for here is even more than just a legal or technical matter, but it's also a moral matter about a decent job, that you can't have workers that are providing work for the state in the manner that they are providing for such a long time, and they don't have protection, they don't have a medical aid, they don't have a pension, they don't have provident fund, they don't have the protection of any that you may think about under the labor legislations of this country.
Well, surely the arbitrator would have listened to what the employer had to say, and so will the Labour Court. What are the arguments that the state has actually brought forward as reasons for this, what you consider to be an abnormal or wrong state of affairs?
Well, of course, the arbitrator will have listened to the arguments, but it is our contention that the arbitrator was wrong, didn't listen to all the facts, didn't consider what we call the justification for a contract that was supposed to be not exceeding 3 months to actually exceed 3 months, because the state did not provide any justification for that matter. We relied on a wrong assumption of a Resolution 1 of 2018 that was signed, that was giving the parties in the bargaining council of the Public Health and Social Development to standardize the remuneration of these healthcare workers. As you will remember that before that, they were employed by various NGOs, they were employed by various Department of Health in different provinces. But what that resolution sought to do was to standardize the remuneration so that all of them, they must get a similar or uniform kind of remuneration. They must have at least a guarantee that it's not going to be there's not going to be a disparity in terms of that. So that it relies on that it regulates the employment. But we are contending that it doesn't take away the act that says you can't have a fixed contract that is more than 3 months unless it is regulated by a collective agreement. As things stand now, we do not have a collective agreement that says that the community health care workers shall be employed for 12 months or 8 months or even 24 months. That resolution that the arbitrator and the state attempted to rely on actually was extended in 2019, was extended once again in 2020, to which they, as a union, we now refuse to be part of that because we couldn't understand how, if the kind of service these people are rendering, you continuously need them, they are of a permanent in nature. Why is it that these people who are providing that service are not absorbed on a permanent basis when the service itself, you shall never wish it away for the longest time to come, especially at the level of primary health care level of the healthcare services that you are providing in this country?
Well, correct me if I'm wrong, it goes without saying that their remuneration packages will go up significantly if they enter into a different arrangement, which then brings me to the next question. Is it not a question of affordability or a budgetary issue at the end of the day?
First, that's not what they're arguing. Of course, they're arguing the issues of that they are paying these the workers through what is called a conditional grant, but that's not the affordability they're arguing. They are arguing a technicality of them thinking that they have a right to do something that the law and the courts in this country have long ruled that even during the era of the labor brokering, that there can't be a temporary work that is more than 3 months. Because one, you create expectation, but two, you demonstrated that this work is actually permanent. So let's talk about what entry level these community healthcare workers were going to absorb if it's a question of affordability. What entry level? All we want is a decent work, is a job security, is a job where workers will know that they've got all the benefits that particularly the people who are providing the public service in this country, because the community healthcare workers are actually performing a public service. They are administering medication in communities, in villages, in townships. They walk long distances without being provided the transport, without being provided assistance in terms of subsidies or any other thing. They work in dangerous areas, but they don't get any profit or any benefit to that extent. So that's one thing that we're dealing with. The question of what is the package of the remuneration, we can come back and deal with that at a later stage, because it's a subject of a negotiation. There's no way an employer, least that one of the state, can be allowed on the basis of affordability to exploit workers, subject workers into conditions of precarity that you must work, no uniform, no transport allowance, no medical aid, no pension, no salary that is a living salary. But because we need your service, just come and continue to work simply on the basis of what is called affordability. So first, that's not what they argued, but that argument can never be acceptable under the circumstances.
Mike Shingange, let's leave it there for today. Thanks very much for your time.